All right. Hello, everybody. Welcome back to episode 3 of Democracy 101, brought to you by White Hat Research Policy Group. I am David Boyles. There we go. There's my name. Sorry. I am the research director for White Hat Research Policy Group. If you are just joining us the first time, this is a series that we've started here at White Hat to talk about issues related to democracy and voting rights in particular, and to talk about the attacks that are happening on democracy and voting rights right now here in the state legislature around the country, and to try to provide some historical context, some background for that, and dive a little deeper into what's going on right now and how it fits into this bigger picture of the history of struggling for voting rights. And so a little refresher, if you were not around for our first couple episodes. In our first episode a few weeks ago, we talked about the Voting Rights Act of 1965, the very famous landmark piece of legislation that came out of the Selma movement during the Civil Rights Movement, which basically sought to dismantle the Jim Crow structures of voter suppression in the South primarily. And we talked particularly about Section 2 of the Voting Rights Act, which was this broad provision applied across the country, banned certain practices, allowed voters to bring suit against laws and voting regulations that were discriminatory. And then there was Section 4 and 5, really the heart of the Voting Rights Act, really what made it revolutionary. Section 4 created this formula for determining certain jurisdictions with a history of discriminatory practices. Basically said there are certain states that need extra babysitting when it comes to this stuff because of their history. And Section 5 then created this, what was called the preclearance provision, which said if you fell under that category, you had to submit any changes to your voting law to the Department of Justice for preclearance, for pre-approval before you could change that voting law. We talked then in episode 2 last week about how Arizona was one of the states that was covered under Sections 4 and 5, primarily due to its history of having racist English-only literacy tests, which they did all the way up till 1972 to prevent Spanish speakers from voting. And then this week, we get into the attacks on the Voting Rights Act that have been happening, emanating from the Supreme Court, and in particular from Chief Justice John Roberts, who we've talked about a little bit. We've touched on Shelby County and touched on John Roberts a little bit before in the previous episodes. But tonight we're going to get into it and also talk about a case that is currently at the court that will probably be decided this coming June that comes from Arizona. It's called Brnovich versus DNC. And it, creates an opportunity for possibly more restrictions of the Voting Rights Act. So we have a great guest to talk about this with us tonight. So I'm going to bring him in here. This is Professor Jeremiah Chin from St. Thomas University College of Law in Miami. He teaches civil procedure, constitutional law. He is also a former Sun Devil here from ASU, as actually a JD from the Sandra Day O'Connor College of Law, also a PhD from Justice Studies, so is a doctor 2 times over, very impressive. And then we have me, who has seen Legally Blonde about 20 times. So that's my level of expertise that I'm bringing. And his research focuses on the connections between race law, social science in areas such as education, housing, voting rights. So a perfect guest to have on tonight. Professor Chen, thank you so much for being here.
Thank you for having me.
Yeah. All right, so let's jump right in and let's talk a little about Chief Justice John Roberts. I wanted to start with him. We talked about him in our first episode because we were talking about the 1982 Reauthorization of the Voting Rights Act. So the Voting Rights Act was originally supposed to be temporary. They thought, by 1970, they'd fix racism, it'd all be over. Didn't happen. They had to reauthorize it multiple times. And in 1982, there was this provision put in that was actually a response to a previous Supreme Court case, the City of Mobile versus Bolden, which had limited Section 2 to basically saying you could only bring suit for instances of purposeful discrimination. So you had to prove discriminatory intent. And so Congress, when they reauthorized in 1982, changed that to say, no, we meant, any law that actually is discriminatory is resulting in discrimination. So they changed that. John Roberts, who was working in the Justice Department at the time, he was a very young lawyer, out of law school, was not a fan of that, wrote these memos arguing that we don't want to make it, quote, too easy for Voting Rights Act violations to be proven in court. So that's kind of the background there. He became Chief Justice in 2005 after William Rehnquist, who we talked about a little last week. After he passed away, he became the new Chief Justice. One thing that's interesting, that's kind of foreshadowing for what we're going to talk about tonight. One of the folks who testified during his appointment was Congressman John Lewis, famous civil rights activist, famous from the Selma movement, who testified opposing Roberts' appointment, saying that we should not appoint someone, quote, with such a strong desire to reverse the hard-won civil rights gains that so many sacrificed so much to achieve. So that gives us a little bit there. And so, Dr. Chen, I think we'll start with this. You're a law professor. I'm sure John Roberts comes up a lot, in your classes. So tell us a little about John Roberts, his philosophy, and particularly his approach to voting rights and the Constitution.
Well, ironically, Chief Justice Roberts came up in class today. I was teaching constitutional law, and we were talking about a case called Parents Involved in Community Schools versus Seattle School District Number 1. And that case involves the desegregation, or in Seattle's case, the resegregation of schools by removing desegregation restrictions. So John Roberts, the Chief Justice, is not only the successor to William Rehnquist, but he was once his former law clerk. When he was fresh out of law school. So the connections run deep, and their judicial philosophies are fairly similar when it comes to race and voting rights, or things like education, where they're so focused on state interests and local interests in creating a system in whichever way the state deems necessary, free from federal restrictions, including any sense of securing racial justice or rights for minoritized populations across the United States. So his judicial philosophy, particularly when it comes to civil rights, is fairly hands-off, right? Life itself will find a way, and nature will course correct or some way, rather than the federal government stepping in to stop racism from happening, because, racism just cured itself after Brown versus Board of Education.
A case which Chief Justice Rehnquist famously opposed when he was a law clerk. We talked about that, I think, a little last week. And that's a perfect intro. And, something we talked about in the first episode, you mentioned that. So he has this very states' rights approach. The states should be left to do, what they want to do. Racism will fix itself, and we don't want to put these impositions on the state governments, right? That's the idea of these federal impositions, which I think is really interesting, because we talked about in the first episode, the 14th and 15th Amendments, which are basically where the Voting Rights Act gets its constitutional authority. And in both of those amendments, these were part of the Civil War amendments. And both of them, 14th is the Equal Protection Due Process Amendment. 15th is the one that guaranteed voting rights for formerly enslaved people, at least male people, and both of them had these provisions saying, empowering Congress to pass law to enforce those provisions, which were basically there because they knew maybe some states, would need that because of, what had just happened.
Right. And both of them have empowerment requirements for Congress, right? They enumerate powers for Congress at the end of the amendment. 14th Amendment has Section 5, which empowers Congress to make laws in order to effectuate the promises of Section 1, which include, nor shall any state deny unto any person the equal protection of the laws, right? So previously we had cases like Dred Scott v. Sanford, which denied Mr. Scott, who was enslaved, but had crossed the Mason-Dixon line and had been living as a semi-free indentured person in the Northern Territories and in Illinois and in Wisconsin. But they denied him citizenship in Dred Scott, right? So the 14th Amendment is constructed to apply equal protection to any person whatsoever, and any powers it gives to Congress The idea behind the 14th Amendment was to give Congress a broad grant of power to remedy the discrimination that had been experienced in slavery. Same with the 15th Amendment. However, then the Supreme Court very quickly, in cases like the civil rights cases, because very few people discuss the fact that we had a Civil Rights Act immediately after the Civil War, which was absolutely gutted by the civil rights cases in 1887, which required that state action had to be a part of the doctrine. So the reason why voting rights get so contentious is because there's a very clear action by the state. The state is doing something to interfere with your voting rights. And under Section 5 of the 15th Amendment, you have a broad grant of power to require that states shall not deny the right to vote on account of your race. And that's usually where the contention comes in. And a part of Justice Roberts' judicial philosophy comes in too, is that when can race be considered? Justice Roberts doesn't like to talk about race, and he doesn't want to deal with race in any respect. In fact, in Parents Involved in Community Schools versus Seattle School District number 1 in 2005, his first major opinion, he says the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. A kind of paradoxical truism that somehow we're supposed to desegregate without ever acknowledging that race itself exists.
Right. That's the thing, seems to be in his philosophy, like, you know, what he sees as, when he sees racism, the only time he sees it is when there is any what he sees as quote unquote, you know, special treatment, you know, for minority groups. So things like affirmative action, or, you know, basically any state power to remedy past discrimination or past injustices. He's opposed to that because he thinks, yeah, we should all be colorblind, but then ignores, like, you know, actual, you know, racism a lot of the time.
Right. Yeah, he definitely, I think race is kind of an absolute no-no for Chief Justice Roberts, to put it, you know, in very serious professional terms, right? It's kind of the hot stove that he doesn't want to touch race at all, because any use of race for Chief Justice Roberts is illegitimate, right? Whereas the rest of the court, even Justice Kennedy, who's fairly hands-off when it comes to race for the majority of his judicial career, still finds that there is a compelling interest in preserving some kind of desegregation or some kinds of integration or some uses of race where the state must necessarily have race included in the law in order to make some kind of remedy. Justice Roberts, even in voting rights, he doesn't want to touch it. He doesn't want race included at all. He just wants states to be allowed to make general laws of theoretically neutral applicability, which is usually what we're dealing with in our modern racial discrimination cases. Legislators aren't so bold as to directly target any one particular racial group. They just, like in cases like Brnovich versus Arizona Democratic Party, that they target a general type of restriction that just so happens to predominantly affect racialized groups.
Right. Yeah, that's where we get into sort of like the intent versus impact. And I mean, but it's interesting though, because, you know, we talked about this in the first episode, even going back into the Jim Crow era, you know, a lot of the time the laws would not say, you know, Black people cannot vote, because that would violate the 15th Amendment. So they would do everything except that. You know, that's where the literacy tests come from, and the poll taxes and all this kind of stuff. They would be on their face, you know, applying to everyone or neutral, but then used obviously, you know, for an explicit purpose. But yeah, like in Roberts's philosophy, you know, unless they are saying like, we do not want this group to vote, it's fine. And if it happens to have an impact,
right,
you know, we can't do anything about that.
Right. Or you'd have to have something like a recording of the Attorney General using the N-word and saying that these people will not be allowed to vote. Right. That would maybe be enough of a smoking gun for Chief Justice Roberts to write. Chief Justice Roberts would probably find in favor of that, right? Because that's just too blatant and too obvious. You said the quiet part out loud, right?
Yeah.
So in other words, as long as you keep it quiet under his constitutional jurisprudence, it's fine to continue with practices that might have some kind of discriminatory effect. It's the intent that Chief Justice Roberts is looking for. And even if that intent is remedial or beneficial based on histories of race and discrimination that permeate all of our society, Justice Roberts says that that mention of race is such a bad thing in our constitutional jurisprudence that it just shouldn't be permitted at all.
Right. Okay. Yeah. So with that, let's get into Shelby County here. So, 2006, that was the last time the Voting Rights Act was reauthorized. It was passed the Senate 98-0. Was very bipartisan. There was a big fact-finding mission by Congress, largely around sections 4 and 5 in particular, about do we still need them, proving that they're still needed. There were 15,000 pages of congressional record, on this. There were studies done, and they kept the formula in place. Passes a few years later. Shelby County, Alabama, frankly, a county from Alabama, the center of the civil rights movement, of the voting rights movement in the 60s. They file suit, and the case is Shelby County v. Holder, which is Eric Holder, who was the attorney general at the time, who's the defendant in the case, because it's basically against the Department of Justice, arguing that Section 5 and Section 4B, which is the formula part, are unconstitutional, exceeding that 14th and 15th Amendment authority. And so as we mentioned, you teach con law. When this case comes up in class, like, if I'm a student, what are we talking about regarding this case?
So with Shelby County versus Holder, this semester I've taught it as a part of the structure of government and the duties of Congress, right? What are Congress's enumerated powers? Usually that's when we talk about things like the power to regulate commerce among the states, foreign nations, and with the Indian tribes. So that gives us our foreign commerce, our Indian commerce, and our domestic commerce clause among the states. However, with enumerated powers under the 14th and 15th Amendment, that's where the court takes a bit of a different tack, right? That's where I mentioned the civil rights cases. That's where Shelby County versus Holder comes in, because now it's what is the power of Congress to act under the 15th Amendment and its enabling requirements, right? So under the 15th Amendment, you passed the Voting Rights Act. As you mentioned, it was 98-0. Justice Scalia at oral argument actually said that this is a reason why we need to closely scrutinize the Voting Rights Act, because it was so unanimous. So the fact that any senator who voted against the Voting Rights Act would look potentially racist to their electoral base is now a reason that we need to strike down the Voting Rights Act, because it is too suspicious. So it's an unvote againstable law, I guess, right? In Justice Scalia's eyes. Though
classic Scalia there.
Classic Scalia. He uses some great terms. If there's anything I admire about Justice Scalia, it's his robust vocabulary. I think he probably kept a spreadsheet of all of these great terms like argle-bargle and gobbledygook and things like that he would use frequently in opinions. But so that unanimous passage of the Voting Rights Act now makes it suspect. And so when we talk about Shelby County versus Holder, I talk a lot about the data that the court uses, right? So Chief Justice Roberts, in his opinion, often cites to the fact that we've made advancements since the initial passage of the Voting Rights Act. So since 1965, there have been huge strides in terms of voting populations, and there's actually been an increased ratios. And the data that Chief Justice Roberts cites to, importantly, is the elections in 2008 and 2012. And he says that Black voter turnout, particularly in these counties like Shelby County, has seen a rapid and exponential increase, the likes of which we have never seen. And so because of 2008 and 2012, we now see a reason that we should not need to retain the Voting Rights Act. It, in fact, becomes unnecessary to our continued use. So without acknowledging the fact that the 2008 election sees unprecedented Black voter turnout, maybe because, I don't know, we have the first Black president on the ballot, right? And so now he doesn't treat those spurious and those extra considerations and contexts that might surround the Voting Rights Act. Justice Ginsburg calls him out for that in her lengthy, I think it's 48-page dissent, where she says that the Supreme Court, or the majority's opinion, is essentially putting away your umbrella while it's raining, right? Just because you're not getting wet. So the idea that the Voting Rights Act has created its sufficient protections for Black voters so that Black voter turnout can increase is now becoming the downfall. It's become a catch-22, right? That the court has kind of locked all of these counties into. Either the Voting Rights Act works, and so we don't need it anymore, or it doesn't work, and we don't need it anymore. Either way, no matter what the numbers say, you kind of can see the path the court is taking, that there's been enough time. So Congress's powers to enact the preclearance formula now becomes suspect and fails the court's analysis, right?
Right.
Ironically for Arizona, though, because of the way that they've constructed their independent redistricting commission, which is a wonderful and beautiful piece of legislation that was integrated into the Arizona Constitution, Arizona can, I think, theoretically never bail itself out, because Arizona is compelled under its own constitution to follow the Voting Rights Act when it's redistricting. So Arizona always has to follow the Voting Rights Act. Even though they strike down the preclearance formula in Shelby County v. Holder, Arizona, under its own constitution, is compelled to follow the Voting Rights Act as a factor taken into consideration by the Independent Redistricting Commission whenever it is drawing new boundaries, which is this year.
Right. Yeah, that's really interesting. Yeah, I knew that. Yeah, part of the IRC is they need these districts that fulfill that requirement. Yeah, I didn't really realize that stays in place even after Shelby County. Yeah,
because Shelby County is clearing out the preclearance formula set by Congress, right? And it's giving that power to the states. In an ironic twist of federalism, maybe for Chief Justice Roberts, right? The state of Arizona decided to uphold the Voting Rights Act.
Right.
Now we have state action succumbing itself to Congress that is also unamendable because it was passed by voter initiative. So good luck to the Arizona State Legislature, because we have the Voter Protection Act, which protects Arizona amendments from being overturned, voter initiative amendments from being overturned.
That's one interesting thing about Arizona, and we'll talk, when we get to Brnovich about, our, vote by mail system here. We have these strangely very good government things in place, better than you would think for a state like Arizona, like the IRC, like our Pebble system, which now, according to the Republicans in the legislature, are suspect, now that they're losing elections, basically. So I want to talk a little more about the data part. This is actually the first time when I was preparing for this, I actually sat down, tried to read the opinions, someone who didn't go to law school. And this was the part, as a first-year writing teacher, that kind of drove me crazy, because this is first-year writing stuff in here. When Roberts starts citing from the findings that Congress found in 2006, he cites some of these things that you mentioned about, there are, significant increases in the number of African Americans serving in elected offices, things like this. He cites these, from the study to prove his point, which is the opposite of what that research actually said, when they passed the Voting Rights Act. And I know you've written about this. I know you did your dissertation on this, about the way social science data gets used in the courts. So I was wondering if you just talk a little more about that, about how, at least in my, my English teacher reading is like, no, you don't do that. You don't cherry pick the data that you like and ignore the bigger context, that goes against what you're saying. So I was wondering if you want to talk a little more about that.
Well, so I think that's a great read of it. But two, there's also strategies that we use to talk about legal cases. So in the first year of law school, you often hear professors refer to something as dicta and something as a holding. And a dicta is anything that the court doesn't want to follow later on down the line, and the holding is the only part of the opinion that the court really wants to follow. So maybe Justice Roberts might try and just throw that away as dicta, just things that he was saying to logically show the progression of his point. But I think what that use of data highlights is the way that he's marshaling evidence is putting the Voting Rights Act in this catch-22, right? No matter what data he picks, if the Voting Rights Act isn't working, then the data is going to show that. If the Voting Rights Act is working, then the data will always tell him that it's working and it's not needed anymore. And if he's the voting rights, and if the data says that that there's Black voter turnout decreasing, then now the Voting Rights Act isn't working, and that's a good enough reason to overturn it. So, as much as I love, Jay-Z, and he says that men lie, women lie, and numbers don't, numbers lie fairly regularly. And it's just depending on the frames that we put upon them, right? Ironically, Brnovich, when he was doing his oral argument, he tried to go for the Mark Twain quote saying lies, damn lies, and statistics, which is not a particularly good way to start an oral argument that you're making for discriminatory effect, right? The data is really going to matter. And so you just have to be clear and intentional in your framing of the data. Chief Justice Roberts, when he frames the data, it's fairly casually. And he's just, like you said, it feels like he's cherry picking numbers. And maybe because he is, or maybe because he doesn't fully understand the data sets in front of him. Justice Ginsburg, in her fairly robust analysis in her dissent, seems to have a better grasp of what the voting data actually looked like, both at the time of the reauthorization of the Voting Rights Act in 2006, and even in countering the Chief Justice's points on the factual situations in places like Shelby County following 2006 and leading into the immediate case.
Yeah, I definitely want to talk about that. So yeah, the dissent, this is the famous Ginsburg dissent. This is what created the notorious RBG, launched 1,000 Etsy shops, and it is very good. And yeah, she really kind of takes him to task, on a lot of stuff that he doesn't really ever respond to. And yeah, talks about Shelby County itself and its history. And then the one thing that really stuck out to me, find the actual data, but so as part of the 2006 reauthorization, there was a study looking at the uses of preclearance from 82, the last reauthorization, to 2002. And I think it was 700 instances where the Department of Justice had to overturn a change in the law because it was discriminatory. Another 800 instances where they had to make an adjustment to it, to make it not discriminatory. And so, again, that's where the umbrella metaphor comes from, that like the reason these discriminatory laws are not going into effect is because, of the preclearance provision. And as soon as you get rid of it, this is what's going to happen. And, to my mind, in reading, the opinions, Roberts just never addresses that, never really has a response to that.
Yeah. But I think to Justice Roberts' point, he doesn't feel like he needs it, right? Because he feels as if the principles of law and the case law that he's inherited from Chief Justice Rehnquist, even to his own previous opinions, like North Austin Municipal Utility District number 1, that one of his early opinions as a Chief Justice that he helped author with regard to Voting Rights Act, where they say it's more of a political question, that in that particular case, they put it off until Shelby County. But in the line of cases that he's inherited, his point is easy to make. The data for him is fairly superfluous, and it's more of just trying to hammer the nail home. For Justice Ginsburg in her dissent, her data is proving the point that factually the law is not grasping the on-the-ground reality, that there is racialized discrimination in voting, that voter turnout is being suppressed, and that voter participation has meaningfully changed based on race because of all of these neutrally worded factors, right? These neutral laws of general applicability are having a disparate impact, and they are affecting particularly racialized populations in different ways, which is what Brnovich is trying to get to, because under this section of the Voting Rights Act, under Section 2, you actually can recognize a discriminatory effect. Under our Equal Protection Clause, for example, the court requires, if it's just under equal protection, you not only have to show discriminatory intent, but you have to show discriminatory effect as well. You need both of them to show some kind of racial discrimination under the Equal Protection Clause.
That's great. Yeah, so I want to get to Brnovich. So one point I just wanted to hit, on the kind of real world impacts. So this case comes down in 2013. The effects were very immediate. Texas had these voter ID laws that had been struck down under preclearance. They literally put back into effect the next day. Like they were waiting for the decision to come down. North Carolina almost immediately as well starts passing these. There was a report from the Brennan Center in 2018, which I thought was one of the most interesting. It was talking more generally about the problem of voter purges of states, taking people off their voting rolls overly aggressively. So there's, people purge voters because they die, because they move. But a lot of states have gotten very aggressive in purging people for various reasons. And again, often, impacting certain communities. And so the thing they found was for the 2 election cycles between 2012 and 2016, those jurisdictions that were under preclearance. And so it's just kind of, so Shelby County leaves Section 5 in place technically, but invalidate Section 4B so that nobody is now covered by the coverage model. So Section 5 essentially becomes moot because no one has to follow it anymore. So all these jurisdictions, including Arizona, come out from under it. So these jurisdictions that were covered had much higher purge rates than the other jurisdictions. And Brennan Center, in their calculations, calculated 2 million fewer voters would have been purged over those 4 years if the Section 4 jurisdictions were purging at the same rate as the non-Section 4 jurisdictions. So 2 million voters possibly taken off the rolls. And you think about, the 2016 election was the first election that happened, first presidential election after Shelby County. And you think about the margins in some of those states, the Trump one was in the tens of thousands. And we're talking, potentially millions of voters here that were taken off the rolls. Like, this has really big impacts.
Definitely. I mean, because the impacts that we're seeing for most of what the pre-clearance formula required, it wasn't just about voter turnout and vote suppression as we consider it today, but it was also about redistricting. So having that pre-clearance formula in place for 2021 would have been hugely important. And so we saw this being attacked on multiple levels after Shelby County. So even if Shelby County hadn't been decided, if Trump still wins the election in 2016, maybe we have a more dangerous outcome where now the sitting attorney general, whether it was Jeff Sessions or Bill Barr, is able to bail out different states, right? Because there's a bail-in provision of the Voting Rights Act and there's a bailout provision. So now states can suddenly, the attorney general can sign off on whatever racist voting laws are being passed in the states. And as long as they pass federal muster, that's fine. So who's in charge is always going to matter, right? Those appointed officials are always going to matter, even with something like the Voting Rights Act. But with the changes to the census that the Trump administration tried to make too, the census is what we use to determine our new districts. So now in 2021, we're dealing with both redistricting and massive voter suppression, which is going to become a huge factor going forward in kind of our aftermath of Shelby County.
Yeah, I think that's really important. This will be the first redistricting post Shelby County. So yeah, that's going to be, interesting as it plays out. Now, especially, because of all the issues with the census, now that's delayed. They're going to be on this short timetable. It's going to be a mess. We should do some more episodes totally just on that. But yeah, let's talk Brnovich.
Well, it's going to be especially important in Arizona because of the independent commission. Oh, sorry to interrupt, but it's especially because of the independent redistricting commission there. Now you've got to have those members appointed. And once they're appointed, they're going to have to sit the maps. And there's been a series of contests over that independent redistricting commission at the Supreme Court, where the Supreme Court actually vetted the constitutionality of that commission, and it passed muster. So that's well enshrined both in the Arizona Constitution and not violation of the federal Constitution either. So the Independent Redistricting Commission is kind of re-empowered now after the previous Supreme Court challenges. So it'll be especially interesting for Arizona purposes.
Yeah, I think, and this, just a real quick thing for viewers, if you're not super well versed on redistricting. So in the Constitution, it basically gives the power to the state legislatures. So basically gives the power to the elected officials to draw their own boundaries, which has created, gerrymandering, which most people are familiar with at least a little bit. You basically can draw your own lines to, benefit you and your party. Arizona, again, was kind of on the cutting edge of this, of creating an independent commission that took the power out of the state legislature and gave it to this independent commission. And that was challenged at the court, and that was upheld that, that was constitutional to do that. I think some other states have followed suit as well. And so, we'll see how that plays out. So let's talk Brnovich versus DNC. Again, Brnovich is the name. Our viewers will know, the Attorney General from Arizona. This was a case that was argued at oral argument in March. The opinion will most likely come down in June at the end of the session. And this was over two voting regulations in Arizona and whether or not they violate that Section 2, which post Shelby County is really the main section that's still in effect now, because Section 4 and 5 are essentially null and void at this point. And so the first policy was a policy about throwing out ballots that were cast in the wrong precinct, not counting those votes for any office. So a lot of places you cast a ballot in the wrong precinct, they won't count the vote for like your congressman and city council, the ones that depend on the precinct, but will count it for senator and president, because everyone votes for those things. Arizona passed this regulation and said, nope, if you vote in the wrong precinct, your ballot goes in the trash. And then the other one, which a lot of people are familiar with, is the Ballot Collection Law that the state legislature passed, which basically said when you get your Pebble ballot in the mail, which you can return either by putting it in the mail or taking it to a voting location or a drop box, that only you or an immediate family member can drop off your ballot. No one else can do that, which the Republican legislature passed because a lot of these progressive groups were organizing, going into communities, especially low-income communities, communities of color, where you had people who maybe didn't have cars, you had elderly people who couldn't, get around easily, and collecting their ballots for them, delivering them, to the polling places, and the legislature, banned that practice. And so the question here is whether those, fit under, when those have that discriminatory impact under Section 2. And this case is getting a lot of attention because I think a lot of people think that it has the potential, to affect not just these regulations, but going back to what we talked about with Roberts earlier, possibly narrowing that whole, the applicability of Section 2, basically. Is that right?
Yes. So the applicability of Section 2 is really going to be at issue because, as you mentioned earlier, they amended Section 2 to make it clear that with regard to voting rights, discriminatory effect can be the name of the day. So the difference between discriminatory intent and discriminatory effect has been a fairly contentious back and forth at the Supreme Court, right? A discriminatory intent is when the legislature does something purposefully with the purpose of affecting a particularized group. So that can be when it's motivated by what the court calls invidious racial animus, or when its desired purpose is to act in the case called Feeney, that they say that it's because of, not in spite of, the effect it has on a particular minoritized population. So again, if Arizona passed these restrictions on ballot harvesting, saying that, hey, we really don't want Navajo Nation to send in their ballots. And so in order to prevent those who are living in the Navajo Nation from sending in their Arizona state ballots, we're going to pass this law criminalizing ballot harvesting, right? That would be a clear violation of discriminatory intent, even under the generic equal protection clause, right? Under Section 2 of the Voting Rights Act, it allows for a broader remedy, something called discriminatory effect, or in the way that Section 2 of the Voting Rights Act characterizes it as resulting in, right? So this results-based test doesn't look at why the legislature might have passed the law. It might have had the best intentions in the world. It might have had a pure-hearted motivation to protect fraud. That's not part of the analysis as far as that section has been interpreted. The only analysis is, does it result in a discriminatory effect on the basis of race in interfering with people's voting rights? And in Arizona's case, the answer from the Arizona Democratic Party is clearly yes. It affects particularized populations, racialized minority groups within the state of Arizona. And so there is a clear discriminatory effect. So now the challenge is going to come down to, how does the court consider that discriminatory effect? Are we going to maintain the language of the act? Or do we find that because the language goes further than our equal protection jurisprudence might require, or even our Section 5 jurisprudence might necessarily require, depending on how the court phrases it, then would we have to divert to need a showing of discriminatory intent in the first place?
Right. Yeah, and then and this takes us back to that memo that Roberts wrote. That was his argument way back then, was that basically we're going to make it too easy to bring these cases if we're just using impact. So he clearly has a vested interest in narrowing that definition, which kind of goes. I mean, in both of these cases, you hear a lot in conservative circles in particular about this idea of judicial activism, legislating from the bench, right? And to me, in my reading of these cases, like, that is what Roberts is doing. Like it seems to be largely Roberts does not like the law Congress wrote, does not think Congress wrote it appropriately, does not like the effects that it has, and is trying to change that law. Whereas, again, the traditional, especially the conservative understanding of the court is, to be restrained, to let the executive and the legislative branches do their thing, have their prerogative, and not step on them. But I mean, to me, that seems very much what he's doing here when it comes to voting rights.
Well, Justice Roberts himself, when in his hearings to be put on the Supreme Court, likened the role of a Chief Justice as being an umpire in baseball, simply to call balls and strikes, right? Which totally removes him from any kind of subjectivity within the process, right? It's kind of hailing that judicial activism that you're talking about, even though in recent cases, Justice Roberts has been accused of judicial activism, like in the National Federation versus Sebelius case dealing with healthcare, right? Roberts finds that the Affordable Care Act is a tax, and so therefore that part of it can survive, right? And so he was accused of treachery most foul from some conservative wings of the government, and saying that he had betrayed their principles of judicial activism, right? So I think judicial activism is an easy frame up for whenever a judge does something you don't like.
Right. Yeah, well, I mean, that one's a really interesting case, right? Because that's the whole thing where, Congress specifically did not call it a tax in the law, mainly for political reasons, because, like, tax is a bad word. And he's like, no, it's a tax, which is true. Like, that part is true. But the idea is, like, yeah, he just, he essentially added that language into the law that Congress did not include itself, right?
Right. A tax by any other name would smell as sweet, So Justice Roberts, for all his, warts and blemishes, at the end of the day, often acts as a very typical textualist. And I think a case like Brnovich is going to be interesting in the result, especially after I personally was thrown through a loop through the court's decision in Bostock v. Clayton County in this last term, right? That was a case dealing with trans rights where you had a trans woman who was fired for reflecting her gender identity in the workplace. And she was fired because of her status as a trans woman. And interestingly, Justice Gorsuch and Justice Roberts found on her side, right, on a very textual interpretation of the Civil Rights Act. So if Justice Roberts, in his, old and wizened years, is sticking to this kind of textual approach that we saw back in Bostock v. Clayton County, we might have an easy case in Brnovich where they just says, well, this is what the law says. It doesn't matter what, the neutral implications, or it doesn't matter that you have an interest in preventing fraud. The fact that Section 2 says results, we have to look at the results. What do the results say? We have a racially disparate result. That's enough. And that's enough for us to overturn that law. So if the logic that Justice Gorsuch and Justice Roberts signed on to in Bostock v. Clayton County last term holds true, we could have a 6-3. If Justice Roberts holds to the way that he interpreted Shelby County versus Holder, where he says, well, when it comes to voting rights, state gets to set the rules. And this state is simply preventing voting fraud. We could have a 5-4. This case, in my eyes, is really up in the air depending on which line of logic Justice Roberts is going to pick. Is he going to follow his... Exactly. Does he stick to his textualism of Justice Gorsuch and Bostock? Or does he follow his own line of reasoning in Shelby County versus Holder, where voting rights is something that the states need to determine and the federal government needs to stay out?
All right. All right. Well, you know what? I think actually that's a great place for us to stop. Would you want to come back on in June when this kid comes down and we can talk about it then and see what happens?
I'd love to. I hope I come on just smiling like I am now. So I'm hoping that it's a good decision in that respect.
All right. Yeah, let's do that. So we will come back to this in June when this case comes down. We'll have you back on and we'll talk more about it. But I think, for tonight, we will wrap up. Thank you again, Professor Jen, so much for joining us. Thank you, everybody, for watching. So we are, for Democracy 101, so we're finishing up our voting rights series. You can watch all 3 of the videos up on YouTube. So go check those out. We're taking a little break. We're going to come back in a couple weeks with some new videos. If you want to check us out, we got our email there, info@whrpg.org. Follow us on YouTube, Facebook, Twitter, all those places. And everybody have a good night.